Thanks for being here. My name is Jesse Cosma. I'm a defense attorney at Stockwell, Harris, Wolverton, and Helfrey. I'm the exclusive defense attorney on all litigated claims involving Curry Insurance. Usually the scenario would be that an employer would be just stuck with the defense attorney that's assigned by their insurance carrier, but in this situation with Curry Insurance, we're pre-designated so you know which defense attorney you're getting on all of your litigated claims. For doing this over 10 years, I've handled every type of litigated case that you can imagine. So I'm in court 2 to 3 times a week for 10 years. So I've basically have seen every claim that you can think of. And that really helps in getting a case closed as quickly as possible. And that's the key in workers' compensation. The traditional defense attorney will have a case open litigating every issue for 2 to 3 years until there's finally some closure. That's a thing of the past, and that's what really differentiates my approach to other defense attorneys. Really the first step in a litigated claim on defending it is a deposition. And that's the first opportunity to get the claim closed, and it's the first opportunity that all the parties are in the same room together. All right, so what we have over my shoulder is an actual deposition taking place. Okay, this is really where the applicant's been placed under oath and subject to penalty of perjury. So this is really where you get the first chance to really grill down an applicant, really grill down the allegations. And this is the best opportunity to have the employer rep present so you can find out all the inconsistencies with the applicant's testimony. So this is what's going on behind us. And really the key to this is employer participation. That's why the employer is so important to be a part of the litigation process. And that's what we have at Curry. Tons of collaboration between the employer and the defense attorney directly. So the best way to describe the workers' compensation system is factual, medical, and legal. On a medical basis, the way that any issue is resolved at the Workers' Compensation Board is if there's a medical issue, it goes to the doctors. It goes to a panel QME, which is basically a neutral doctor picked by the state. Now, by the nature of workers' compensation and by the rules, if you have a 1% industrial aggravation, you're on the hook for 100% of the medical treatment. So generally speaking, the medical side of workers' comp is a loser for the employers. The next area is legal. The laws that are written, the Workers' Compensation Board follows these laws in the labor code, and they're all slanted in favor of delivering benefits to the injured employee. So you're really at an uphill battle with regard to the legal aspect. That leaves the last battleground, which is really the factual issues. And you'll have cases that are denied on a factual basis. And that is where cases can be won or lost. And that, the most important part of that is having the employer participate. So what I mean by factual is that when you have an applicant claiming a left shoulder was injured and maybe both shoulders were injured, but you have the employer's participation in the claim and you have an employer level investigation, and you can contradict whether it was the shoulder, both shoulders, or which body part was involved. If the medical reports contain inconsistencies or lies from the applicant, then all the medical reports that come out of that information, those are actually poisoned, and those aren't admissible into evidence. So once you learn this information, then you can get a good result in a case. All right, we're here at the Van Nuys Workers' Compensation Board. This is one of the actual courtrooms where the litigation happens. And anytime you have any type of settlement, it's not valid until a workers' compensation judge approves it. So it's really important to know which judges to avoid and which ones to get your case in front of. And that's a lot of gaming the system. That takes years and years to figure out which ones are favorable versus which ones are going to end up a lot more litigation.